My lords, in 801, the matter is showing for the 12th. I request for it to be not deleted.
Not to be deleted. Yes.
Much obliged.
May please, my lords. My lords, 2011 civil appeal, my lords. My lords had specifically directed for listing after 2 weeks. However, no specific date was given. That's why it's not getting listed, my lords.
What is the issue?
My lords, it's pertaining to parity of pay between direct recruitees and promotees, my lords. Any specific date?
They'll give the date.
Deeply obliged.
803 minute 12th September is indicated, my lord. Urgency is grateful.
My lords, this is an matter, my lords, between the state of Karnataka and Tamil Nadu, the drinking water project, my lords. The date is not being shown. I just want early hearing, my lords, of the MAs, my lords, which have been filed in a disposed of appeal in 2018, my lords. Disposed of appeals, MAs were filed by state of Tamil Nadu. For the last 7 years, the matter is pending, my lords. Those MAs are pending.
Water dispute.
Water dispute, yes, my lords. Water dispute. It's a drinking water project proposed by the state of Karnataka, my lords.
State of Karnataka and?
Tamil Nadu is the other side, my lords.
September के end में.
Great.
Raki week नहीं यार. Specific date. We'll give a fixed date.
Grateful.
I on board.
So grateful.
It's a 2026 appeal. Parties have settled the matter that this civil appeal be listed for disposal. Any early date? Obliged.
My lord, the petitioner is a leprosy patient and cured in 2016. And she has been cured in 2016, and since then she is looking for the job, and the contempt has been allowed last time.
I'm not in a position to hear you.
Last time it has been heard on the 1st of the April, and after that we have not got any date.
What is the matter about?
It is a leprosy patient. Leprosy patient. And she has cured in 2016.
My lord.
Your lordship, I seek your lordship permission to mention 2 matters pertaining to NEET PG examination.
Pertaining to?
NEET PG examination. Your lordship, one is an after notice matter, writ petition number 456, and the second issue regarding the transparency was kept pending when the single shift order was passed. And the second is writ petition civil 48426 diary number is pertaining to the discrepancies, marks discrepancy and other discrepancies which has crept in.
It's after notice or?
Your lordship?
It is after notice or fresh matter?
Your lordship, first is after notice, second is fresh. And your lordship, another matter at item number is listed today.
You mentioned it before the court number 3 because the matters are listed there.
Lordship, another matter, item number 40 is listed before the Honorable Court today.
We'll tag it along with that.
My lords, and lord's permission to.
Lordship, item number 40.
So what is the issue in that item number 40?
Your lordship, there is.
Let it be called out. We'll see.
My lords, I'm seeking permission to file a listed mentioning pro forma because I'm an intervener. I need to seek my lord's permission because the registry is not accepting my listing mentioning. So I'm only seeking permission to circulate a listed mentioning before the mentioning branch.
In which matter?
My lord, this is UP Judicial Services Recruitment Examination. I am at rank 69 out of 303. The issue before this honorable court is with respect to cutoff marks because people are saying. So I'm only asking for listed mentioning may be accepted.
Okay.
Much obliged.
Your lordship, I'm seeking to mention.
IAs for modification of stay have been filed by the respondents in these batch matters. They are all senior citizens whose gratuity is withheld, though the issue of dearness allowance being reckoned for gratuity is settled by.
After notice?
Lordship?
After notice or?
Yes, after notice.
NMD was there after the.
Lord,
My lords,
May I-
seeking your indulgence, my lords, this is the Ashok Kumar Sharma matter on the Forest Conservation Act. My lords had heard it on Friday. On
You
20
already granted protection in that.
No, my lords, my lords had directed the MOEFCC to file a reply on our IA. My lords, for some reason, it's not come in the order, my lords. That's the only thing.
Who is to file reply?
My lords had directed the ministry to file a
Oh,
reply
yeah,
to our IA. It's not in the order. That's all, my lords. That's a limited.
Your Lordship, one suspension of sentence matter, Your Lordship, which is listed for 4th September, it may not be deleted, Your Lordship.
Okay, not to be deleted.
Your Lordship, I am seeking to mention, this is the appeal of 2002, Your Lordship. And appeal moved by the state of Uttar Pradesh. Matter is pertaining to government employees. Some of the employees even might have retired and some has died. Only question is, Your Lordship, this matter is referred for 9 judges bench. Then Your Lordship kindly request now, court is working in full instance, 9 judge bench may be constituted, Your Lordship.
Whenever you consider it.
Your Lordship, kindly consider.
Lordship, of first matter under one NI Act. In this case, accused has been convicted. I am here before you, Lordship, against the suspension of sentence. Lordship, warrant has been issued on 28th of August. That's why I am praying for urgent listing in this matter.
My Lord.
Lordship,
Yeah. Still come tomorrow.
Lords, I mentioned a
your
matter. Lords, I mentioned a matter on Friday last month, on 29th of August, to list a matter on for today, Lords. The said matter is listed for 4th of September. On 3rd of September, the matter is listed before the trial court for the framing of the charges. Lords. The petition,
They are also lot of stuff.
Lords, the petitioner is a the gynecologist, and on petitioner is a gynecologist, and on 3rd is a gynecologist.
So we can take an adjournment there on that date, sort of stuff. You tell that the matter is district to Supreme Court.
May I mention?
Lords, the matter before the London trial court is listed on 3rd of September. That's the only. If,
Then tell the learned trial court that the matter is listed before the Supreme Court of Force.
please.
Lord, may I mention, my Lord, the
Yes, madam.
My lords, this is the first case in the Nithari batch of cases. My lords knows he was convicted.
Yes, but now Nithari, in that even your review is rejected. I think.
Lords, we have filed a curative petition, and what the situation now is that while in 12 cases, your lordships have acquitted him and rejected the same evidence.
Curative,
My lords, this,
you have to go before the public.
if it,
It was decided by whom? Both the judges must have retired now.
yes, my lords. My lords, it would be a very apt case for a,
One case, court will just come to our Uttar Pradesh. पहले सर्कुलेट करके तो open.
Your Lordship, I am also seeking one matter.
an application for an open hearing.
Yeah, I have already told them.
Most grateful, my lord.
My apologies.
Lordship, I am seeking.
A fresh matter, my lord. This is a matter concerning a minority institution, Christian minority institution in the state of UP. My lord, they are facing a lot of adversities from the authorities to run the institution. My lord, I filed the petition last night, yesterday at 1 a.m. My lord, I'm seeking, could be listed.
So why Allahabad High Court is on leave?
My lord,
Allahabad High Court is
no,
on.
my lord, it's not on leave, my lord, but we're seeking some urgent relief, my lord.
Urgent relief, Allahabad High Court also can grant it.
My lord, it could, if it could be listed tomorrow, day after, my lord, whenever.
Friday.
Your Lordship, I am seeking to mention one matter.
My lord, Thursday, Friday is.
Thursday would be Friday for one practical purpose.
My Lord, I am seeking to mention one.
How many mentioning, Mr. Yadav?
Your Lordship, this is second matter. I am so sorry, my Lord. This matter was listed on 14th of August, but Your Lordship, unfortunately, matter was not reached any Monday or Friday, Your Lordship.
What is it about?
Matter is a civil appeal, land acquisition matter, but petitioner is 85-year-old lady, Your Lordship.
ठीक है, लगा नहीं.
Lord, may I mention, my Lord, your Lordships had
Well,
directed an open court hearing, my Lord, in this review petition, which has sought a review of the One Shakti judgment, my Lord, whether 2017 and
I
2021.
think it will have to go. The special bench लगाना पड़ेगा.
Lord, if it,
We will keep it on some day at.
Lordship, to have it at Monday next, my Lord, if it's the Constitution bench, my Lord.
We'll see after the.
I'm grateful.
Your lordship.
I didn't.
With your lordship.
मुझे लगा ले रहा हूँ.
With your lordship,
I
please.
How much time it will take, Mr. Pai?
It will take some time, my Lord. There are a number of MAs and a number of review petitions, my Lord. Mine's a review petition, but there are about 8 or 9 MAs, so it will take some time, my Lord. But your Lordship will list it, my Lord, on so that a schedule or something can be fixed, my Lord.
No, we'll only.
It should be, yes,
In the face of.
Yes.
Or not to work.
yes, my Lord. Yes,
Lord,
With
identical.
my lord, with your
तो 3 बजे रखते जाएंगे.
with your lordship.
Finally mention a fresh matter. My lord, this year, this is an SLP filed by the state of Rajasthan, wherein the Honorable High Court has granted a blanket stay in 4 SLPs against the accused.
In blanket SLP in?
In four quashing petitions, stay has been granted with regard to the arrest of the accused. And in the 5th FIR, the investigation has been transferred to the Additional Director General of Police when the matter was sub judice before the trial court and is still sub judice before the trial court. My lords may have it any week, any day of this week.
Lord, I am also mentioning a connected SLP.
Which is the High Court?
Rajasthan High Court.
Rajasthan High Court.
Because orders have been passed to direct registration of an FIR against me. I am not even a party. Everything is done behind my back.
Friday.
Please.
My lords.
With your lordship's leave, I'm mentioning a matter. With your lordship's leave, I'm mentioning a matter. This is the Bangalore doctor child custody matter, my lord.
I have assigned a bench for that matter.
Since my lord and Honorable Justice Mr. K.V. Vishwanathan had
I have already assigned the bench.
My lords, may I mention, my lords, writ petition with diary number 49471, my lords, it's about the unprecedented ecological, my lords, disasters in Himachal, Uttarakhand and Jammu and Kashmir, my lords. In Himachal alone, more than 320 people have died, my lords, landslides, all farmlands destroyed, my lords. I'm praying for an earliest listing possible.
We will-
Please, yes, my lords. Much
With the
obliged.
lordship permission, may I mention a matter, my lords? My lords, I'm requesting for urgent listing of the SLP, my lords, where the petitioner has been declared PO by the London Trial Court, my lords. However, the High Court has have issued notice but did not grant the interim relief, my lords. He may be arrested, my lord, any time, my lord.
When was the order passed by the High Court?
The High Court passed the order on 24th of, my lords, on 21st of August, my lords.
With my lord's kind permission, may I mention a matter? This is a set of 12 Section 11 petitions which had been filed. Lordships had issued notice in the lead matter and tagged the remaining 11. The remaining 11 being fresh are not being listed. Lordships had passed the order dated 23rd of July.
My lords, may I kindly mention.
So the identical matter is coming on Thursday, my lord. This is regarding AICT matter seeking extension of time schedule in Parsunal.
My lords, may I kindly
My lord, may I
mention.
mention one matter?
The petitioner has been denied the promotion to the 3rd year of BLLB, and the mid-semester exams are starting from tomorrow, my lords, 2nd of September.
My lord, identical
lord, may I-
matters are coming on this Thursday.
My lords, the exams are starting from tomorrow.
My lord, may I mention
Bless
one matter, my lord? These institutions are approved by the AICT, my lord. So far as application is concerned, my lord, that has been not communicated due to last date is over, my lord. 15 September is the last date for taking admission, my lord. Petition are numbered, my lord. Just I am requesting to list this matter on Thursday, my lord, coming. Grateful.
My lord, identical fresh matters are coming up on Thursday, 4th of September. This was ordered by you in the last date to be listed today, but it is not listed. So please, if you may list it on Thursday, my lord.
My lord, may I kindly mention one matter? One PIL has been filed yesterday. It's on the same subject matter. Item number 50 listed today. It was filed yesterday. ma'am.
What is it about?
It's about ethanol blending in petrol.
About?
Ethanol blending in petrol.
So today there is some matter.
Yes.
Whatever you pass an order, it will follow in that matter.
My lord, my grounds and prayers are different.
We'll see when it is called out.
Was in item 1, my lords. During the pendency of the transfer petition, the parties have entered into a settlement. My lords, it's a marriage of not only 5 months, and the husband has agreed to give 60 lakhs to the wife. My lords, we've got the demand draft. There are two FIRs and one domestic.
Really? But service is not complete. Let the service.
No, they're there. I am the respondent. My lords, I am the respondent.
It's my transfer petition,
Yes.
my lords.
Why don't you settle the matter?
No, we have settled. We have placed the settlement agreement. My lords, IA number, the 199,305. I have agreed to pay 60 lakhs and my lords, I have got the demand draft in court. My lords, the prayer is at page 16, my lords. Divorce and my lords, 2 FIRs and 1 domestic violence case.
Grant of mutual divorce and quashing of the entire litigation between the parties on the ground of irretrievable breakdown of marriage. The parties were married on 22nd of April 2003. However, it appears that soon after the marriage, the relationships within the parties became poor. They started residing separately from May 2024.
To 7 December, sir, May 2024. Yes, sir.
It's your ever.
Yes, sir. Yes, sir.
Correct. It's not in dispute that parties are living separately from 16th of May 2024. Correct. Various matrimonial proceedings are pending within the parties on account of matrimonial discord. Correct. Parties are therefore, well, since the relationship between the parties has reached a stage where it has become irrevocable, irretrievable, the parties have decided to give an end to their relationship. The respondent number 1 has the respondent number 1 husband has agreed to pay an amount of rupees 50 lakhs towards settlement of all dues of the petitioner wife. First, the parties have also have decided to give an end to all the pending litigation between them. Parties, both the husband and respondent, are young age. We find that the fit case wherein the court should exercise its jurisdiction under Article 142 of the Constitution to give an end to their relationship so that they can start their life afresh. The parties of person present in the court, they reiterate about the settlement. The demand of you will hand over or you have the demand of rupees 50 lakh is already handed over by the husband to the wife. That view of the matter. Application is allowed in terms of pay clause A and B. The registry will draw the decree accordingly.
Luckily, there was no BMW car. As I was saying, luckily there was no other, the BMW car, there was no other demand, luckily.
We had a matter wherein 100 crores demand was rejected.
Yes.
100 crores offer was rejected, sorry.
My lord, your lordship would remember that matter from Bombay.
Yeah, that's what I'm saying.
Yes, my lord.
The day before yesterday,
yes,
there was an application because the wife is protracting the. You are appearing for the wife in that.
No, my lord. I was.
Yeah, you are with Dr. Singhvi.
Yeah, not with Dr. Singhvi, but another matter, my lord. Yes. I knew, my lord. Your lordship had dealt with earlier also, where your lordship had granted 30 lakhs maintenance or rent or something.
When I was sitting with Justice Nageshwar Rao.
Yes. Hello.
That's so great.
Your Lordship, kindly allow me 1 or 2 minutes to explain about the petition. Your Lordship, this is a petition about to.
You go to the Parliament and ask them to amend the laws. It's not our jurisdiction.
Your Lordship, just allow me 1 minute. This is regarding.
And how can there be a set line of guidelines to the judges as to how they should exercise their discretion? We can't encroach upon the discretion of the judicial officer. Neither the legislature can also.
I mentioned only two issues. Your Lordship, in the recent time, it has been seen that the amount of the fine imposed on in the various criminal cases by the lower courts is too little.
Go before the parliament, ask your parliament to increase the fine.
We have been to the Ministry of Law, we have been to Ministry Law Commission of the India, and our case was referred to the Home Ministry, and we pursued the case in the Home Ministry. They have not replied. Your Lordship, even the traffic offences attracts much more time, like 10,000, 5,000.
Yes, sir. Thank you, Mr. Papa.
We are imposing 100 rupees.
Thank you. Dismiss.
200, 500.
Thank you. If you argue anything further, we'll have to dismiss this cost.
Please, my lord. Plus, there have been series of your lordships. There have been series of the order of the Calcutta High
There is a dispute between two groups of the trustees.
Well, it's not. That's not submitting lordship. Lordship by record submission is not a dispute between two group of trustees. It is the water body which has to protect it. Way from 2014, I have been after it, lordships, and lordships, High Court has clearly passed thrice the orders. In spite of that, the municipal corporations record that yes, there is encroachment. Lordship, just have a look at the municipal corporation's order. And we will include the at 116, your lordships. That's at start of 113 at 116 after lordships, after the order of the High Court, 3 order of the High Court, municipal corporation conducts the meeting, it does the inspection. At 116 clearly records, as per the inspection report, a major portion of the said pond has already been converted from pond to Vasti without any permission from the competent authority. Hence, in the pursuance of section 17 of West Bengal Fisheries Act, where with notifications as such, the executive committee has been read as follows. Clearly directed to be restored to its original position, which was the order of the High Court. High Court.
No, but then you are the trustees of the trust.
Well, trust. I had been the trustee of trust, but that is not the issue. The water body has been encroached upon by the other persons and other local persons over there, lordship, many persons over there. And your lordship, this very issue of restoring back the original water bodies. Lordship, may I just pass on the 2 orders of the ordinate bench, your lordship? Well, it's not a question of practice.
Notice.
Please, madam. Well, may I request only for returnable date subject to a lord's convenience?
Yes. 8 weeks, 6 weeks.
Oblige, my lord.
ऑनरेबल कोर्ट में नवीन शर्मा ऑल राजस्थान बजरी ट्रिब्यूनल प्रदेश अध्यक्ष हूँ राजस्थान से। बजरी सैंड माइनिंग राजस्थान में इतने वर्स्ट पोजीशन पे इलीगल चल रही है माय लॉर्ड।
हमने तो ऑलरेडी ऑर्डर पास किया
था माय लॉर्ड, लेकिन वो ऑर्डर्स मेरे उसमें कंटेम्प्ट पिटीशन में थी, वो डिस्पोज ऑफ कर दी ऑनरेबल कोर्ट ने इसी फरवरी में। मुझे कहा कि तो लीगल वे से आप दोबारा चाहिए। एक सिमिलर मैटर हमारे यहाँ आपके यहाँ पेंडिंग है 10587/2019, उसके अंदर वेरियस ऑर्डर आपने किए हैं। आप चाहो तो मैं एक ऑर्डर आपको दिखाना चाहूंगा, उसमें सारा मटेरियल है। सीईसी को भी आपने भेजा था, सीईसी ने अपनी रिपोर्ट भी सबमिट की थी ऑनरेबल कोर्ट को। और इसके अंदर मैं निवेदन यही करूंगा, एक बार आप ये कोर्ट ऑर्डर देख लें, एनेक्शन नंबर 1 पेज नंबर 28 से 32। मैटर कोई सुनने वाला नहीं माय लॉर्ड, वहां ऐसा जंगल राज हो रहा है, हम लीगल ऑपरेटर्स मर गए हैं, एनवायरनमेंट को बुरी तरह क्रैश किया जा रहा है और लीगल ऑपरेटर चल ही नहीं पा रहे हैं वहां पे। ये आपने ऑर्डर किया था ऑनरेबल कोर्ट ने 10587 में पेज नंबर 13, पेज नंबर 30, पेज नंबर 30। (10587) SLP नंबर है जो ऑलरेडी आप एडमिटेड है आपके यहाँ। We find the issue of the sand mining state of Rajasthan has become extremely complicated and probably chaotic. The parties before us blame each and others. The present situation in these circumstances we consider.
कौन इलीगल माइनिंग कर रहा है, क्या कर रहा है, उसको किसी को भी पार्टी बनाया नहीं।
जी माय लॉर्ड,
जो लोग इलीगल माइनिंग कर रहे हैं आपके कहने के हिसाब से
पूरा राजस्थान कर रहा है माय लॉर्ड। एक नॉट ए सिंगल पर्सन, thousands of pupils are doing that. और ट्रांसपोर्टेशन, अब वहां स्थिति ये हो चुकी है, हम लीगल ऑपरेटर्स तो फ्यू हैं और अपनी खुद की रिपोर्ट के अंदर एफिडेविट में स्टेट ने एडमिट किया है कि 70% वहां इलीगल माइनिंग हो रहा है. काइंडली सी इन पेज नंबर so पेज नंबर 71 CC रिपोर्ट. काइंडली सर, एक मेरा रिक्वेस्ट है ऑनरेबल कोर्ट से, 10587 को इसके साथ टैग कर लिया जाए तो काफी वो होगा, है ना. और दूसरा एक रिक्वेस्ट हो रहा है कि मेरा बच्चा, अभी मैंने उसको एडवोकेटशिप करवाई है पूरी, और उसी ने पूरी रिट हम दोनों ने मिलके की है, तो उसको मुझे असिस्ट करने की परमिशन दी जाए सर.
उसको आर्ग्यू करने के लिए बोल दीजिए ना. वो
नहीं, आर्ग्यू तो मैं ही करूंगा सर. ही इज लिटिल गाय, ही डोंट नो अबाउट दिस मैटर्स.
ठीक है.
चिरायु शर्मा एडवोकेट है, इसी साल 25 में उसको मैंने कंप्लीट करवाई एडवोकेट.
उसको बाकी के केसेस भी करने के लिए बोल देने तो आपके बेटे
वो मेरे साथ सीखेगा माय लॉर्ड. थैंक यू माय लॉर्ड. ऑलराइट.
This was not a punitive action at all, Mills, with all due respect to the High Court, because in the
notice.
Well, there'll have to be a stay because after 12 years, they have now directed us to take them back and then conduct.
Stay also.
After 12 years, Mills.
Okay, notice stay.
Grateful.
You are, give the names of the respondents for whom we are very sure.
May it please. Despite your lordship's directions in December 24 and the requirement which is there under the act and the rules, I've got the act and the rules compiled here for your lordship. Despite that, the NCRT and the government are responding to us and saying that we are not implementing, we're not monitoring, we don't know. Just one page, if your lordship sees page 679, where the RTI reply is of 7th May 2025. The NCRT admits they don't have any of the information regardless of your lordship's directions. It's a very sad situation. Just give copies. Yes, page 600. If your lordship sees this, the RTI reply as recently as May 2025, 7th May 2025, 679 Millards, Annexure P12. All the questions that we have asked them regarding the inclusion of this in the textbooks and in the curriculum, they say we don't have the information, NCRT doesn't. And the direction your lordship is giving was very clear.
Issue notice.
I'm grateful.
6 weeks.
Very pleased.
My lord, through this civil writ petition, I seek.
No, now the judges are retired, so how can we ask the another judge to pronounce the judgment?
How, sir?
The judge has already retired now, so how can the judgment be pronounced?
Sir, the case was transferred to another bench.
Huh?
The case was transferred to another bench.
So it will have to be reheard by the another bench. These are unfortunate, but what can be done now?
Sir, my house is getting continuously damaged, sir. Sir, look at the condition of my house in actual P3 page.
So most we will request the High Court to decide it expedition.
I moved multiple complaints, multiple representations to the Honorable Division Bench over there. The matter was already reserved for pronouncement, and 2 times the pronouncement wasn't done. Then suddenly a rehearing was conducted where an attempt was made to retrospectively legalize this illegal shopping mall. So thereafter, I brought this to the notice of the Chief Justice.
Madam, what we will request the Chief Justice to know the petitioner's grievances that
So, the Honorable Chief Justice had to issue a notice that any reserved matter which has to be reheard has to be first put up before the Chief Justice for assignment of a new bench. Thereafter, sir, again, it was transferred to the next bench, and again, long adjournments are being made.
So we are requesting the bench to hear it.
Sir, I requested, sir, they just put my case into the
We
order.
are requesting the bench now.
Thank you, sir.
The petitioners give us is that the bench which has resolved the matter after hearing for a long period not pronounce the judgment in as much as one of the judges had already, one of the judges retired from the office. It is further given that after reallocation of the matter to another bench, the same is being adjourned and not being heard. We request the bench to which the matter has been assigned to expedite the hearing of the matter and decide the same. We are inclined to make such a request since on an earlier occasion the matter was already closed for hearing and reserved for judgment. Dispose of with a force. Dispose of as a force. With this, maybe your matter will be heard soon.
May it please your lordship. Lord, in fact, none of my submissions is considered at all. If your lordship will just see page 3, para 5, what the Honorable Court says. After noticing this, in fact, deemed confirmation was my second submission. My first submission was it was punitive because of that anonymous complaint. But just see para 5.
Where is the order? Not confirming your services.
The order, there is no order. I am just being discharged by P23. But just
So
see,
there is no stigma attached to the order.
just see page 3, my lord, para 5. Because I had filed detailed written submissions also, para 5. In this regard, the court is unable to accept the contention of the petitioner since concept of deemed confirmation is anarchy, which has been given up long time in service jurisprudence. Now kindly see para 7 in the middle. The concept of probation,
Yes.
just in the middle, deemed confirmation is a perilous concept in service jurisprudence, which has long since been discarded since it erodes the power of the employer to assess work and conduct behavior of the petitioner. Now, my lord, apart from this, there is nothing, and it notes integrity doubtful. It does not note the last report, the final report, which is of 11/12, which I will show to your lordships. But the factual position is like this. I am appointed in 2008. The question of my confirmation is first considered on 21st September 2011. My confirmation is deferred because at that time,
Better practice.
my lord, the submission is this, my lord, that it is completely stigmatic.
Better practice.
It is completely stigmatic.
How can it be stigma?
Not because kindly see P15, 2 pages. Just see P15. At this point of time, my case, just see P15.
Page?
P15 is page 129. Kindly have it at page 133. Or 132. 132 in the middle of the page. This is the report put up before the then Honorable Acting Chief Justice, which goes to the committee. Now, in the middle, lower half of the page, thereafter, Shri Ankur Lal, Civil Judge Junior Division, was transferred. If I can read just the para above it, because these are the circular of the High Court saying that where there is a report of doubtful integrity, what is to be done. Now, accordingly, the following matters are pending for consideration before the full court. Shri Ankur Lal is required to be posted at district headquarters as per court's instruction. District and session judge of Ankur Lal may be asked to forward every contested judgment delivered by the officer along with their own comments in accordance with the instructions of 1994. This happened, my lord, and on 16th May 2012. For 6 months, my probation is extended. After 1.5 months, this is being recorded. It is relevant to point that following complaint is pending against Shri Ankur Lal, the then Civil Judge Junior Division, the District and Session Judge, by letter dated, has forwarded an anonymous complaint purported to have been made by the Bar Association Firozpur, where he has cited 4 cases in which Ankur Lal had passed wrong and illegal judgment. District and Session Judge has sought the comments of the judicial officer on the complaint, submitted his own report, which was put up on 15 June. Thereafter, orders of the administrative judge, who conducts a preliminary inquiry, submits his report on 11th August before the Lordship, which were placed before the acting Chief Justice. Then, my Lord, this report is then asked to be put before the committee. Now, what is important is that on 16th May 2012, the administrative committee says, my probation should be extended by 6 months, which goes up to December. This report comes in July, or this anonymous complaint. In July itself, the matter is sent to the committee, and on 18 July, I'm discharged. Whereas 2 months earlier, the committee had said probation should be.
If you want, we'll place it before court number 2.
My Lord, in fact, unfortunately, the problem. My Lord,
thank you, Mr. Bhattacharya.
My Lord, at least the stigma should go. The man is practicing.
From the perusal of the order by which the petitioner's services are not confirmed, it cannot be said that there is any stigma attached to the petitioner's non-continuation of service, non-continuation of the service of the petitioner. As such, we do not find that the cases may not go into place. Since the order is non-stigmatic, the non-confirmation of the service of the petitioner is not, cannot be interpreted with by this.
May I, if your Lordship,
ask you to practice, we will be better off.
He is, my Lord. It will not come in his way for any future employment. If your Lordship can add that line.
If you want, do you want the Chief Justice we should request the Chief Justice for his elevation?
My Lord, that is capacity to practice and his
capacity to practice. For that, this things hardly matter.
If your Lordship is possible for your Lordship to say that this will not come in his way for any further appointment or assignment.
Yes, and it's not stigmatic. If the government wants you to be appointed as Advocate General or Additional Advocate General, this will not come in the way. For Punjab and Haryana, you have many.
I'm not going to make any comment. But the point is that actually it happened like that, Lord. This and if
he has been out of the employment for now 15, 17 years. Why should we know?
The order, but the Registrar Vigilance makes that inquiry as if he's an appellate authority over my judgment.
If you want us to be sent to court number 2, we will send it.
I don't mind.
Then we don't know what order you will get. At least now you have got this order.
I told him, Lord, that that one of the facts is that 2 of the honorable judges of the committee are now adorning this bench. Not only 2, Lord, the third member also.
Only 2.
The committee was Justice.
Yeah, there are 3-member committee. Out of the 2 are in this court.
Correct. Great.
Lordship, this is the case where the land was, my Lord, taken over without a preliminary notification. My Lord, the High Court thereafter, my Lord, passed orders directing them to acquire it under the 2013 law, my Lord. Now, my Lord, thereafter there were 2 rounds of litigation, my Lord, they had come up. But now the award has been passed, my Lord, and the problem is at 168. The award is at page 153. If your Lordship has 168, my Lord. And my Lord, obviously, I can obviously, my Lord.
How can that be a contempt?
My Lord, I'm just pointing out one fact, my Lord. And then obviously, my Lord, the High Court has given me liberty to challenge it so far as market value is concerned.
Yes.
But just have a look at 168. This is part of the award which has now been made, my Lord. And if your Lordship sees, my Lord, the serial number 1 is the market price. 2 is the multiplier now under the statute. Now, my Lord, 3 solatium has to be 1 plus 2. They have not given it on that, my Lord. Solatium is, my Lord, on compensation under 30, which is, my Lord, what the statute says, which means serial number 1 plus 2. But they've only given, my Lord, solatium on the first part, not on the second part. That's very clear from the statute. Solatium is on compensation, not the market value.
How can it be contempt? You tell us how can it be contempt?
Lord, your Lordship said, I'll explain, my Lord. Your Lordship says that the acquisition, my Lord, has to be in accordance with the new law. The new law, my lord, provides for a preliminary notification. They have not made that. But let it be, my lord. By deeming fiction, the court said you treat it 1/1/14 as the date of the preliminary notification. Though there is no notification issue, they're required to issue that notification. But be that as it may, my lord, the section 30 is very clear that solatium must be on 1+2. If your lordship looks like that, they've not even given me 100%, my lord, on 1+2. If your lordship has to look at the section 30, because today there is a multiplier, your lordship knows today under the new law, there's a multiplier. Automatically, whatever the market value is, that is serial number 1, my lord, the multiplier of 1 to 2, they've given a multiplier of 1. Let it be, my lord. I'm not complaining. If I have any other request, my lord, I'll do that. But my lord, the solatium, which is 100% on compensation, is very clear, my lord. It has to be on 1+2. That's the problem.
Dismiss. Want to withdraw?
My lord, your lordship may then say that liberty has already been granted. I'll pursue my remedies in a
Since the petition has already been granted, liberty to take recourse to the remedy as available under section 64 of the Act. We are not inclined to entertain the petition.
Lordship.
Item 12, I'm seeking a week's accommodation note. The senior counsel is in. I'm seeking a week's accommodation note. The senior counsel has become unwell. Next week, no, he has hospitalized.
Who?
Mr. D.S. Naidu was hospitalized on Saturday. So,
but if it is dismissed today, it will be dismissed without cost. If it is to be dismissed in the presence of Mr. Naidu, it will be dismissed with cost. Choice is yours.
There's something in this.
Choice is yours. Then don't tell us on next week.
I appreciate
that. We have not warned you.
Yoshi may have it on next. Have it next week.
Yes, but next week it will be dismissed with cost commensurate with Mr. Naidu. No, we have read it.
Please have it next week. Please have it.
But be ready to pay cost.
And your lordship will be very kind to us.
That even if it is to be dismissed today also it should be dismissed with cost.
Your lordship may have it next week.
Okay. If you want to take the risk, you take the risk.
Lord, your lordship have been very kind to us. Lord, your lordship.
Mr. Radkani has faced it last week. The award did not tell us. We better ask Mr. Naidu.
I'll take the section. Your lordship will kindly have it next. He's not unwell. I'm not able to.
We are warning you today.
I understand. I understand.
Then we will not change our order like we changed in Mr. Radkani's matter.
I am the catch-22 situation.
No, we are warning you because such frivolous litigations have to be cut. So we are doing it, but then we will not change our order like we did in Mr. Radkani's matter because
I'll myself argue. I will not bring Mr. Naidu. I'll myself argue. Please have it next week.
or whatever it be. If you want to argue next week, then it's a different matter. But then again, I will have to go by my learned brother's advice.
He or she will be very kind to us.
Yes,
grateful.
May I please your lordship. This is a position of the guidelines of 2020, which was operationalized in 2021. There are only 13 orders of various courts, including this court, holding that I don't want anything till the festivities are over. If at all your lordships are inclined, anything after that.
Reasonable 4 weeks.
Ah, that's fine. I'm obliged. Because I
Now we don't know to. I came from Mumbai yesterday only.
Number 37, which is a connected appeal.
Yes, they're all connected.
I'm appearing in 14 and 39. Look, I'll just delineate the broad contours.
Very well considered judgment.
I'm sorry, Mlod?
Very well considered judgment.
Look, sometimes, look, sometimes those judgments are written very well, but sometimes judgments are written very well, there's no doubt. And it appears that everything is considered, but I would place before your lordship, no, this is a matter where the essential points have not been.
Every point has been considered by the division.
Several points have been set out. What the High Court,
Several points have been set out.
But
Each point has been independently considered.
No, I'm sorry. The reason. Let me just place. The main. Let me put what I perceive to be the main issues where the Honorable High Court has gone completely wrong. There may be a consideration, but what the High Court's conclusions are completely wrong. Just first, let me just put it in perspective. The project consists of actual construction in the sea of about 6.25 acres. 6.25 acres of the actual construction, that is the surface which is covered, is 25,116 square meters.
Is it not having the permissions from the competition authorities?
Those permissions are what a challenge, Lords. What applies here, Lords, is 7E of the Lords, Environment Impact Assessment Notification 2006. No permission taken. It is completely bypassed. Now, in this case, Lords, furthermore, Lords, the CRZ4, this is a case where both CRZ4 and 7E both applied. The permission which was required was the permission of the central government, the MOEF, and not, Lords, here neither the State Impact Assessment Authority has been consulted, nor the MOEF's Central Impact Assessment Authority. What has been done is the MCZMA, that is not the Maharashtra Coastal
Management Committee.
They have unilaterally taken a decision. Now, according to us, it is not within their ken at all. So let me just place two or three factors before your lordships. The first thing is, Lords, this is a case where it's a huge, giant-sized construction running more than 0.6 of a kilometer, more than 600 meters into the sea, into open sea. And, my lords, the actual construction as disclosed by the MCZMA to the court is about 6.25 acres. The coverage of that area is more than 13.3 acres. That is what is enclosed within the construction, because there are areas where the sea is enclosed within it. There's a sort of a big tennis racket shaped jetty. So about 13.3 acres. The Supreme Court complex, our main complex, is about 17 acres. So your lordship can imagine the magnitude of this in the open sea, 600 meters out. And then, my lords, you have a coverage of 6.25 acres of construction. Now, what had happened here was that a very, very detailed study had been done, because the Bombay Port Trust and the Maharashtra government had mooted this, that a passenger water terminal is required in the year 2000. They had constituted a committee known as the Howe Committee, the consultants, which are HOEW, and those consultants had not just, they had gone into it in every detail of every alternative site. That is 6 different sites were taken, and all sites, including this particular site, was considered. There was a detailed interim report in the year 2001. That report was then culminated after consideration, and after that was accepted by the state government, Maharashtra government, the Bombay Port Trust, and all other authorities accepted the report. Then a final report came to be made in 2003, saying that it should be at the ferry wharf, that the only feasible area is Bhaucha, and ferry wharf, next to ferry wharf, there is the Prince's Dock, which is contiguous with it and joint, where there are empty terminals and godowns which are available. So the Howe report, and I want to just take your lordship through a few pages of the Howe report. That report has not been even placed. The MCZMA, when the Maharashtra Maritime Board moots this project afresh, they don't even place before the MCZMA that report. And the High Court says there's no need to place that report, because this is now a new project. So please just see the report. Volume 2 may just be taken for a moment. Volume 2 of the first SLP.
So 25-year-old report.
Volume 2. Now, Lordship may just see the executive summary of the interim report. First, my lord, we come to page 309. 309 sets out the background. The present modes of transport between the island city of Mumbai and Navi Mumbai on the mainland separated by waters of Mumbai harbour by rail and road. Continuity in rail and road links is maintained by bridges, etc. Then was the distance between the waterways, etc. And then para 3.
But water has flown after that. There is an expressway.
No, we are only. I'm only on the passenger water terminal. We are not on anything else. We are not saying that this particular project is the same as that. We are saying the passenger water terminal project in Mumbai remains the same because it is a terminal for the purpose of ferries to go from Mumbai to the mainland, to Mandwa, to Navi Mumbai, to other Uran, etc.
Vashi, Uran.
All of them.
So this project also envisages Kalyan, Dombivli also.
That's right. So this project, your Lordship will kindly just see that all the different alternatives were considered. And after your Lordship may just see page 313. 313 for a moment. All different alternative sites, because the government said, please consider all different sites.
Because in which year this?
In the year 2000. Ultimately, 2003 was the thing. Now, please see, your Lordship, just come to page 315. Approval of the interim report by Government of Maharashtra. Series of meetings, just 315 minutes. Series of meetings were convened by the Government of Maharashtra to know the progress of the study and the views of concerned parties with regard to the proposed. This is PWT's passenger water terminal, and also to impart direction to the study. The final meeting was held in the boardroom of the MBPT on 28 November 2001, when all concerned parties met. As requested by the agenda for meeting enclosed, the consultants gave final presentation of the interim report. The meeting ended with the approval of the recommendations of the interim report, and the consultants were asked to complete the detailed feasibility report by making a preliminary design and studying the financial viability of the project with focus on the ferry wharf as the finally approved location for siting of the proposed full-fledged passenger water terminal. The communication from MVPT to this effect is enclosed as Annexure 5. Now, MVPT is the port authority. And that one sec, please.
We are reading everything. Even if he doesn't want to read, we have read it.
So now the Lordship may just note here that letter of MBPT is at page 585 of the same report. Lord may just note that.
Why is skipping reading the very next line?
It was, however, suggested. Yes, I'm reading that. It was, however, suggested that an additional landing jetty ought to be provided near Radio Club. This jetty would be used for embarkation and disembarkation of passengers traveling to New Mumbai and to Mandwa. Now, this jetty, they wanted a pontoon jetty because it's only for the non-monsoon months, because it can't be used in the... So, if your Lordship kindly just sees further down, at page 316, Lord, the top of 316, it was suggested that a landing facility in the form of pontoons and jack-up platform may be considered on the north of the existing Radio Club pier. And
when the matter was came up before us,
yes, and
Mr. Hegde appeared, it was thought to be projected that this is only for the owners of the yachts and all that.
No.
The elites.
No, I don't know at the interim stage what was argued.
No, that was argued.
That was
what was argued was that this is a fight between Amchi Mumbai and Kanchi Mumbai.
No. I don't. I disown that completely as far as I'm concerned. There's a very serious issue here, Milord. There's a serious issue here that if you have carried out this very, very detailed study and found only one area to be feasible.
So suppose if the Constitution is enacted in 1950. Are the parliamentarians not entitled to have an amendment to the Constitution after 25 years?
Let me make the point. The point is, if there is no reason for departure from this, and in the situation has become worse.
The passage of 20 years itself, maybe, and it is not as if the present project is being implemented without any studies.
Yeah. Now, your Lordship will kindly see the. Every single thing was considered at that time, and it was finalized. Now keep that aside for a moment. All I'm saying is this report ought to have been placed before whichever authority is considering it. if the MCZMA was considering it. According to us, they had no authority because the authority was with the state environment impact assessment authority or the central impact assessment authority under the act, under the Environment Protection Act, read with the 2006 notification and the CRZ notification. But even if MCZMA was to consider it, surely this report needed to be placed before them because they have to see whether that situation exists or not. Where the existing, all facilities are already available there. Now, please come to the order. If your lordship kindly sees on how the order deals with the issue of if my lord just comes straight away to para 50. The High Court goes on the basis, kindly come to para 59. Page 59. Page 59. My lord Sardar. We are concerned with 7.2 and 7.4 of the CRZ notification, which is a separate notification from the Environment Impact Notification of 2006. They are under two different regimes. Now, as far as the CRZ is concerned, your lordship will see para 48. It is also relevant to mention here that under unamended para 7.2 of the CRZ notification, I'm on volume 1, my lord honorable.
Yes, we are on the same page.
Yes. It is also relevant to mention here that under unamended para 7.2 of the CRZ notification 2019, all permissible activities in CRZ 1 and CRZ 4 area were to be dealt with by the Government of India, Ministry of MOEF and CC, and MCZMA was merely a recommendatory authority, and final CRZ clearance would be issued only by the central government. However, by notification dated 24th November 2022, para 7.2 of the CRZ notification 2019 was amended, and amended provision carved out an exception in respect of certain activities, including standalone jetties, for which CRZ clearance has to be granted at the level of concerned Coastal Zone Management Authority without requirement of referring the proposal to the central government. In order to notice the change brought about by the amendment, the provision of unamended and amended para 7.2 of CRZ notification 2019 are required to be read in conjunction, which are reproduced below in the form of a chart. Now, your lordship will see the unamended one said all development activities and projects in CRZ1 and CRZ4. This is admittedly in CRZ formula, which are regulated or permissible as per this notification shall be dealt with by Ministry of Environment, Forest and Climate Change for CRZ based on recommendation of concerned CZMA. Then the amended one, all development activities and projects in CRZ1 and CRZ4 areas which are regulated or permissible as per this notification shall be dealt with by the central government for coastal regulation zone clearance based on recommendation of the concerned Coastal Zone Management Authority with the following exceptions, namely standalone jetties, salt works, slipways, temporary structures and erosion control measures like bunds, seawalls, groins, breakwaters, submerged reefs, sand nourishment, etc., which shall be dealt with by the concerned Coastal Zone Management Authority. So temporary constructions, standalone
jetties also.
Yes, but this is the whole point. This is a jetty. This is not a standalone jetty. This is a jetty in a port. It's in Mumbai port. They admit that it's an expansion.
Mr. Singh, both you and Mr. Rustamji and me are all aware about that area. Is it in the Bausa Dakka or it is in the...
Both of them fall within the Mumbai port. The port water, all the waters in the harbour.
It is coming next to the Gateway of India.
That's right.
Gateway of India is not providing sufficient. It has only 5 jetties which are found to be inconvenient, and therefore.
So we are not against shifting of the jetties or decongestion. We are saying that it should be decongestion must take place by moving it to a place which will actually decongest. Here, by moving it 250 meters away, there is no decongestion.
Do we possess the expertise? All the bodies have been taken on board. The traffic.
The actual body which is to be consulted is not consulted.
Which is the body?
That is either the state Environment Impact Assessment Authority or the Central Environment Impact Assessment Authority.
Whether this amendment of 2019 has been challenged.
This doesn't apply. Look, please see, we are talking.
Hold on, factual aspect has found that it is covered by a standalone jetty.
My learned friend wants to just.
May I deal with the query that my lord raised? May I deal with the query that my lord raised? before the Bombay High Court, it was not in dispute that this area falls within Mumbai port. Indeed, it cannot be disputed. The areas that are used for unloading and loading passengers are covered by passenger rules issued by the MBPT. The boats are licensed to the MBPT, and the MBPT is in entire charge of that area. So that it falls within the port cannot be in question. Now, may I just, my lord, in 5 minutes outline the 3 issues that were before the court. The contention was this. This is a massive project in an area which is ill-suited to support it because it cannot bear the...
It is coming at the place where the radio club is situated.
That's right. A little bit, my lord, adjacent to the radio club, going out about half a kilometer into the sea. 25,000 square meters is the size. It's about 10 times the size of Gateway of India. I mean, I don't even need to get into all that. The fact that it is huge and will dwarf the entire area is not in dispute. It cannot, the fact that it is massive and that will entirely dwarf the surrounding area cannot be disputed. It's a different matter that that area is in fact a heritage sub-precinct. I'm not even going there for the time being. Now, the arguments that were raised before the High Court were these. 4 fundamental issues. Number 1, the issue that my learned friend raised, which was, my lord, I'm not even going to ask my lord to look at the papers. The first issue was, in 2002, when you considered in detail where the best location for a passenger terminal was, it was unequivocally Ferry Wharf and not Apollo Bandar for various reasons that the consultant put forward, which hold good today. What were those? 1, it is not fit to support that load. 2, it is not able to handle that traffic. 3, it is a heritage area. It is not advisable to have it there. As opposed to this, Ferry Wharf has the connectivity. It is a wide open space where there is no residential accommodation. There's no construction only close by. We are now finding the MBPT wants to lease out that plot after the matter was argued before the High Court. It was not pointed out to the High Court. My lord, it's something like a 30, 40 acre plot or more, 40, 50 acre plot, which they now want to lease out for commercial gain. Let's leave that also aside. Now, my lord, the question was this. In 2002, 2003, the government accepted this report and said, yes, do this, but also do a very small pontoon jetty which will float at Apollo Bandar to take care of 1 or 2 vessels. It's not a large thing at all. Can't be compared with the present project. It goes to sleep for 10 years. Government having said, yes, we will do it, chooses not to do it. The MBPT having said yes to the report, nothing happens. This then, my learned friend will give me a moment. This is absolutely correct. In 2014, they revive it again. They go, my lord, to the MCZMA, who recommends it to government. The matter again goes into, that is again a different type of structure that is proposed to the present one, but let's not get diverted there. So the first submission was, what has changed in terms of the factors that made that a better and this a worse location in that point in time? The High Court deals with this by saying 2 things. 1, that was intended primarily for movement between South Mumbai and Navi Mumbai. This is not just South Mumbai and Navi Mumbai. It is also Alibag.
Mandwa, Uran.
Not in my submission, that makes 0 difference. Which is why I think my learned friend is right when he says it may sound reasonable. The point is, where are you best suited to put the PWT in South Mumbai? That position has not changed. Are you better off at Ferry Wharf or are you better off here? And has anyone considered it? Answer from CZMA, no, because that's not our job when someone comes to us for a sanction. So that question remains unanswered. Why not Ferry Wharf? That's one. Now the second question. We'll have 2 notifications according to us come into play. One is the Environment Impact Notification of 2006. That notification requires projects of a certain size to obtain an environmental appraisal, go through a scoping process, which involves also members of the public. It is scrutinized ultimately by a state or a central level agency, and a clearance is granted. Now, my lord has seen this project is huge. It is massive. One would expect in the ordinary course that this get a clearance. That's the basic requirement, an environmental clearance. The entry reads, and I can show it to my lord from the order, it's extracted. It's at page 43, but I will read it for my lord. Ports, harbors, breakwaters, dredging. This is the entry 7E, and this is what it covers. Please note, ports, ports of the EIA notification of 2006.
Which, it's at page 43.
It was our case that this not only is, my lord, according to us, activities that can be related to a port, and a jetty is fundamental to a port. What is a port? It's an area where, my lord, goods and passengers are loaded and unloaded on vessels. That is exactly what a jetty does. But it got better because...
We'll not pass an order up to without hearing.
You know, in our case, it was much stronger, and we pointed this out. Why? Number one, you are admittedly within Bombay Port. Admittedly, this was not in dispute. Number two, the boats that ply to and from are under the control of the MBPT. The routes are fixed by the MBPT. They're registered by the MBPT. Fares are fixed by the MBPT. And the landing areas, including Apollo Bandar, is actually designated by the MBPT as a landing area for passengers. There are passenger rules, my lord, I can show my lord that. So in this case, what do you have? You have a massive jetty in the middle of a port, admittedly in a port, which, my lord, relates directly to the activities of the port. In our submission, this amounted to nothing but expansion of a part of the port. Now, the notification covers both initial setup and expansion. What is the answer of the High Court to this? I'll tell my lord. Jetties are not specifically mentioned. It only says ports and harbors. But the High Court accepts in the same breath that if the jetty were to fall within a port, it could not be considered a standalone jetty, my lord. It ought to be taken into consideration.
Held that.
I'll show my lord that. So, my lord, ultimately the court holds, because this is not the MBPT's project, we will not consider it to be covered by 7E. But the question is not whether it is the MBPT's project. The question is, are you in a port? So there is no answer effectively in my submission. If my lord sees the reasoning, it's just 3 paragraphs. And I can show that to my lord. There's no real answer on this. That's one. The second aspect was the CRZ notification. Now, the CRZ notification, my lord, learned friend has read you the clause. There is no doubt that a jetty is permissible under the CRZ notification. No doubt. The question is, who is to give the clearance? Now, if you look at 7.2, it says, my lord, for areas falling in CRZ 1 and 4, which this is, it must ordinarily be only recommended by the MCZMA, that is the local state coastal zone management authority, and be granted by the central government. However, if you are one among a certain bunch of items, standalone jetty is one of them, then the MCZMA has the jurisdiction. There is no doubt that the MCZMA has, in this case, issued that clearance. The question, therefore, is it standalone? Now, I'll tell my lord what was argued. We argued that standalone means a jetty and nothing else. You cannot have a VIP lounge, which you want. You cannot have a food court. You cannot have parking facilities for 80 vehicles, which earlier you said you could not do under CRZ 1. You cannot have all these other add-ons. It ceases to be standalone. The state argued there's an amphitheater also, for good measure, which they... But they say that...
Recorded in the script, the amphitheater will be used only as a waiting area for the passengers.
That is correct. That has been, so to that extent, that has been addressed. Now, the state argued that that is not what standalone means. Standalone means it must not be connected to a port or its infrastructure. The problem for the state was, this is indeed in a port. So the only argument was it's not connected to our infrastructure. What does that even mean? Now, my lord, the learned judge takes neither route. The learned judge holds that it is standalone because it is dealing with passengers and not with cargo. Where does that come from? Not from the CRZ notification at all, but from the EIA notification.
7A of the EIA.
Which says based on the cargo handling capacity that you either go to the state authority or the central. So in short, the learned judge has imported a notion from the EIA notification which has no application. So, my lord, in my submission, I'm not even getting into the larger argument on sustainability, and I'll just summarize that for a moment.
Proportionality.
The question really is this. Have you examined whether this project, may not, we keep saying sustainable development. At some point, that has to be actually measured by action. Have you examined the carrying capacity of that area? Is it able to sustain this kind of project? Now, the entire rationale for this project is we want to decongest the gateway of India, single point agenda.
Well, there are only 5 jetties.
Right. So therefore, accent is only on the gateway of India. My lord, I posed a slightly different question. If you want it to be sustainable, my lord is aware of that road. It doesn't stop at the gateway of India. The road carries all the way down to the radio club. That promenade is used by thousands of people for recreation. You have the Taj Hotel at one end, radio club at the other. The whole area is frequented. The whole area is congested. What the question that we raised was, you should be looking not just at the gateway of India as a monument, but at that Apollo Bandar heritage sub-precinct, or call it even the Apollo Bandar area. Now, what are you proposing? You are proposing to make 5 jetties 20. All that you are doing...
12.
20. 10 with
10 into
2 berths each.
So 20 at a time, with the attendant traffic, with the attendant people coming, etc. All that you are doing is, you are shifting that 250 or 300 meters down the very same road. The MMB affidavit said, yes, it will now be distributed along the entire road, the congestion. One more fact, which I think is critical. Their own traffic simulation study says, after going into it threadbare, asking people where they are going, taking samples of who is coming for what to the gateway area. This is the statistic. 75%, their study, not mine, produced by them. 75% of the persons who come to go on boats visit the gateway first. And the report says that 75% will first go to the gateway and will then walk down the road to the new jetty. Now, my lord, I raise a fundamental question here. Of course, it's a wider question. And of course, ordinarily, these are matters left to policy. But they are certainly open to question. Are you then seriously doing this entire project for the 25% who will not visit the gateway? 75% of the volume of people, your own study says, will continue to visit the gateway. So then, my lord, ferry wharf and so on start assuming a different significance. And all of these questions I would submit, my lord, I'm sorry, I have taken a lot of my lord's. But it's a really important project for that area. I think the residents have a legitimate concern. I must tell my lord that there is not one examination in both EIAs that are on record. EIA is not done under the EIA notification, but under the CRZ notification. Neither of them actually goes into the impact on traffic and congestion, which are the 2 most important factors for the residents. You know, those roads are already choked to congestion. Double parking is the norm on all of them. They're all narrow streets. They're not meant for this kind of density. The question is, has that been gone into? And in my submission, the answer is no. So for all of these reasons, my lord, this requires serious consideration. And I would submit, my lord, I would, my lord, humbly request, my lord, that this really requires to be gone.
Well, there's one more.
My lord, may I read the paragraph on standalone and the reasoning as to why it has been considered standalone? Please see para 50 and then I'm done.
Para?
50 at page 60.
Yeah, that's what.
Sorry.
No, please read that. Please read that.
Therefore,
my lord has got it. Yes. Now, this is the consideration on why it is a standalone jetty. It is necessary to examine whether the project is a standalone jetty. Para 5.1.2 of the notification dealing with regulated or permissible activities spells out ports and jetties as different and distinct activities. The CRZ notification creates a distinction between ports and jetties. My lord, I don't think it really does, but all right. Similarly, the activities mentioned in 5.4 also make a conscious distinction between ports and jetties. Now let's look at what the reasoning is. Therefore, the term standalone jetty as contradistinct from a port would mean where no porting activities are carried out and the facilities are used only by passengers. Now pause here for a minute. Is it being suggested that the loading and unloading of passengers does not happen at a port? Whether it's an airport, my lord, or a seaport. And then next.
We have passenger ships coming to Mumbai, the international passenger
There's
ships.
in fact a passenger terminal. A port can have jetties.
Huge ships and cargo.
The next sentence.
A port can have jetties for tying boats and the passengers boarding on and alighting from such boats. Such a port, please note this, having jetties would not be covered by the exceptions under 7.2, which is to say it would be covered by the earlier part which says it must go to the central government. But the fact of the matter is, my lord, this is a jetty in a port. That has been lost sight of. In other words, the learned judge, having arrived at the correct conclusion, doesn't apply it to our case.
The next sentence actually turns it on its head.
And then it says every jetty which does not have a port facility. Would my lord just see the last three lines? My lord, last three. I'm sorry.
One second.
I'm sorry. I got it.
Yes, my lord, kindly have a look at page 43. My lord, what is the fundamental error the petitioners are committing in equating port with jetty? Kindly come at page 43.
40.
43. Page 43, the chart which my learned friend has shown, which is, my lord, thereafter amended undisputably, and the amendment is not under challenge. That is also undisputed. The lordship say, my lord, ports, harbors, breakwaters, and dredging. Correct, my lord? Now come to column number 3. Less than 5 million TPA of cargo handling capacity. The port, more than 500, that doesn't make any difference. What is required is the port.
More than or equal to.
Yes, my lord. A port is something where cargo handling facility is there. Your lordships are aware, my lord, big ships come, there are cargo stored, there are storage for cargoes, huge, my lord.
Like JNPT, for example.
Yeah, yes, my lord. Your lordships are right.
Bombay Port Trust. Now it is MPT, Mumbai Port Trust.
Yeah, Mumbai Port Trust, yes, my lord. Now, my lord.
Or Sassoon.
I'm sorry.
Or Sassoon Dog.
Yes. No, that's a, yes, fishing.
Yes,
That's a fishing.
Sassoon Dog is only for fishing purposes. They have the godowns and then those.
Very much.
Cold storages, etc. Cold storages are also there in every
Very much
port
a
because some cargo contains some material which requires
No,
to be.
Sassoon Dog is only for fishing.
Yes. Now, my lord, kindly come to 4. So and so million ton of cargo handling, then general conditions will apply. Note, capital dredging inside and outside the ports or harbors. Here, my lord, no dredging is involved. Lord, now please see, my lord, page on this issue, page 59 and 60. Lord, my learned friend has shown the chart. And your lordships may bear one thing in mind, my lord, that there is a recommendation by the Navy also for this particular.
That we have seen. The Navy has not recommendation, it has given its NOC.
No, they have given recommendation. If you
So that.
page 742. Page 742.
And one of the berths has to be given to them.
Yes,
That's their condition, I think.
yeah, yes. 742, my lord. That's where, my lord.
Volume 3.
Our reply.
Lord, yes, but this is in our reply before the High Court. Volume 3, my lords. Volume 3, page 742. This is, my lord, not in my backyard kind of a petition. They are all residents of nearby thing. Your lordship gets B, no security clearance by Indian Navy. That's what their submission was. And now we are dealing with it. The proposal to set up a floating jetty or pontoon near the Gateway of India Monument, however, could not be pursued due to security concerns raised by the Indian Navy. The Western Naval Command noted that the Gateway of India Monument, which is a symbol of strength and resilience of citizens of Mumbai, attracts the attention of terrorists seeking to achieve publicity for their wanton acts of destruction. Now, please see, the Western Naval Command recommended that in the interest of security, instead of right next to the Gateway of India Monument, a jetty be constructed near vicinity of Radio Club at Apollo Bandar. This, per the Navy, would immediately decongest the Gateway of India Monument, enhancing the cleanliness of the surrounding area, allow tourists to stroll the plaza of the Gateway of India with relative tranquility, unhindered by passenger traffic, increase the attractiveness of the promenade from the plaza of Gateway of India to Radio Club, and provide significant upliftment of the area. A copy of the later dated so-and-so, my lord, this is 2011, there is a typo. Now, my lord, again coming back to, my lord, the findings.
Do you have a copy of that?
Yeah.
Exhibit C. It is at
Lord,
page
they
number?
have not annexed, my lord, but I can share, my lord, my copy. My lord. Kindly, you have another. My lord, kindly pardon me, there is only one. Lord, in fact, if you are a public spirited man, you must annex it. So jetty is completely different from a pod. That's how, my lord, the finding is recorded and rightly recorded.
Yeah, thank you.
Decongest the entire city. But 2011, but now this is not a floating.
So there we are asking for that Annex C, the letter of the Navy dated 30th of May 2025.
I think that this is the one.
This is 30th of May 2011.
Malord, 25 is a typo. Malord, I pointed out, it is a typo. But I pointed out, possibly it missed, my lord, I couldn't be clearer. It is a typo.
This recommends for floating jetty, you see.
Yes, my lord, but if even floating is permitted, that's what I'm saying. Now we are having a permanent jetty. The reason is this, my lord, this jetty would. No, kindly visualize from a different point of view. My lord, when he says traffic congestion at a particular port, my lord, we had a my lord, NOC from the traffic also, and the consideration is, my lord, this jetty can be used now to reach Navi Mumbai, Mandwa, Alibag, etc., etc. Now the travel time, my lord, would be 1/3. Number one. Number two, the traffic which will otherwise go on road, on Bombay city roads to Navi Mumbai, Mandwa, Alibag, etc., will be reduced substantially. So it would be decongesting rest of the area. So we cannot, my lord, we will have, we means
Where is the study regarding the traffic management?
my lord, it's
620.
page 620.
Volume 3.
Volume 3, page 620.
This is the traffic.
No, just to point out, this came after all permissions had been granted. So it has not been.
Obviously, it can come only thereafter.
It's not been considered by any authority.
Has it been considered by the High Court?
It has not, was not really put.
So let us see.
This is the one that says 75%.
No, only, the traffic part comes only if we are permitted by other authorities. If our permission is refused, there is the question of traffic management being considered. So kindly see traffic stimulation study report. My lord, I am not going into it, just to show, my lord, that your lordships, that traffic part and the decongestion part is considered. If your lordships, my lord, now come to page.
Where is the recommendation in this report?
Lord, 6, please,
Lord,
if you don't mind, please, if you don't mind. Not in my backyard should have a limit. 644, my lord. Scenario C. The result of scenario C demonstrated a significant improvement in traffic conditions in the vicinity of the Gateway of India and along P. Ramchandani Marg. Compared to the earlier scenarios, there was a notable decrease in vehicle queues length at the Gateway of India. This reducing in queuing can be attributed to the effect of implementation of dedicated terminal facility for passenger pickup and drop-off, which streamlined vehicle movements and minimized random stoppage near the entrance. Additionally, the removal of non-street parking along critical stretches of pre-Ramchandani Marg further enhanced roadway capacity, allowing the smoother traffic flow and reducing congestion. As a result of these combined measures, there was also a marked decrease in delays for vehicles traveling along Ramchandra Marg, improving overall network efficiency. Then kindly see 648, my lord, the conclusions. Last paragraph, my lord. However, scenario C demonstrates significant benefit when additional traffic management measures are implemented in conjunction with terminal development. The removal of non-street parking along P. Ramchandani Marg, provision of clear lane markings, and the establishment of dedicated pickup and drop-off facilities within the terminal building contribute to a marked improvement in traffic conditions. Scenario C achieves a 46% increase in the average speed, a 65% reduction in average delay, and 73% decrease in average stop time compared to the base scenario. These results affirm that combination of terminal development and proactive traffic management is essential for optimizing traffic flow and enhancing the overall efficiency of the transport network in the area.
So where will this traffic be parked? It recommends that the P. Ramchandrani Marg will be a non-parking area.
Yes, Malad.
So where will this parking go?
Malad, on the terminal itself, we have a parking area.
Just show the plan.
I'll just show the plan, Malad. I'll just show the plan. No, not brochure, that with.
Yeah, that's one.
Yeah, but no, it's here, Malad. This is something. Yes, we have, my lord, an internal parking, so that there is nothing, no parking on the road. Two pages are different pages there. Where is the parking? Lord,
That's for the users of the terminal.
my lord, your lordship sees, my lord, this box, colored box. On the left-hand side, my lord, that is parking area. Which can, my lord, accommodate 150 cars. And your lordships are aware, this is, my lord, a floating population. It doesn't remain there for the rest of the day. 150 cars, my lord, would be, there is an inside parking area provided.
Do you have a map showing the overview from the Gateway of India and
Yes. Lord, I have your copy. And I'll also show, my lord, another difficulty which we are facing is this. And for my lord Justice Chandran also. Lord, there is a jetty, for example. Jetty has 5 boats lined up. If I get the ticket of the 5th boat, I'll enter the first boat, jump to the second boat, jump to the third boat, and reach 5th boat because of the congestion at Gateway. Lord, which is this, Lord, photograph? And I'll show you, Lord,
With the learned solicitor's permission, in the third matter 39, their brochure is annexed. That all these pictures are in the brochure.
And I'm showing everything. There is nothing to.
Because that brochure is annexed. All these pictures are there.
And there used to be accidents, people, children, women falling.
Can you just hand us?
Because sea is never stationary.
in that Kumarko, while going to the boat, we had to cross one boat.
Yes, here 4 boats, if you are in the 5th boat. And sea is never, my lord, static. Obviously, my lord, it
Just show the overview.
overview is this.
Which matter? So he's saying that the brochure itself.
We will show it. Is
The
this
brochure was in serial
I
number
think-
39.
In my petition, my lord, it's at page
My lord, this
774.
may be a better
Oh,
view.
in
That's
item-
all I'll show from the brochure also. You have
Item 37, it can be seen.
No, not brochure, this overall
Item
overview.
37, you can see the, which one have you handed up? That's yours.
31 page number.
My lord, 774 of my volume 3 gives you a view from the brochure. Perhaps.
That is serial number 37.
Volume 3. Page number?
My lord, 774
774. Nithari.
in volume 3. There are a series of, my lord, graphic sort of
Yeah,
versions.
This is the full brochure.
And my lord, every authority has considered whatever was within their domain and permitted.
My lord has 774.
Yes, yes.
My lord, that gives you an idea of how the jetty will lie in relation to the surrounding area
7.
from the air. 774, my lord has?
No, the overview of the how the entire area from Gateway of India.
I have given, my lord, one.
It only shows Gateway of India.
My lord, this small.
It doesn't show the proposed jetty and the Gateway of
No,
India.
it does show, my lord. It does show. Radio
Gateway of India.
Radio club. It's one end, my lord.
Whole jetty.
I'll just, my lord, mark and.
My lord, at 774, the Gateway of India is shown. Top right-hand corner.
No.
Shows Gateway of India, but how would the project look after the jetty is constructed and the Gateway of India?
Exactly this, miss, 774. This is the proposed jetty. 774.
My lord,
My lord has-
my lord, your lordships are right.
No, 774 shows how the jetty would look, but
That's right.
how would the area look from the Gateway of India to this?
From the gateway to the.
The entire overview
Yes.
as to how that entire area would look after this project is implemented.
My lord, this is the best.
It is not in this. my
The
lord.
brochure starts at 769 and various pictures will show their, this is their projection.
This is our projection, so there is nothing to hide. My lord, your lordships are right.
In 774, your lordship
If
can
you
see
can-
gateway in the
Mr. Singh,
background.
Please. I'm for the entire Bombay population. You have a few individuals who do not want personal inconvenience.
No,
Please
no,
have a-
no, no, no. We
Well,
are saying
kindly
that
have a look
whatever
at
you
this,
do,
my lord.
How the entire area would look.
No, kindly, my lord,
Because I have personal knowledge of that area also.
obviously, my lord, your lordship.
But then you would like to have, as to how the area would look.
also your lordship, my lord, the honorable chief justice would keep in mind one very
Can
important
your
thing.
lordship see
That this
788
jetty can only be for 8 months of the year. So you build this huge vanity project of
not a vanity project, but
invading the sea when you have Princess Dock and that available, which is 12 months, which is all weather. That is what that huge report of 350 pages said, that you cannot build.
Forget about that 2000 now, whether they have not conducted the studies now.
But
Your lordships may
they
come.
admit that this is only for fair weather. This can only be for the non-monsoon months.
It
This
is
jetty is of
always-
no use in the monsoon months.
Lord, 788, my lord, would your lordship see, my lord, in that?
4
Item
months of
30.
the year, this will be not in use at all.
Yes, 788 gives an idea. 788 gives it.
788, my lord, perhaps, my lord, is what your lordships
But
are.
it's really the same as the other.
Only please. Please allow me. Lord, 788, your lordship.
Therefore, that promenade is not affected. That promenade will continue.
Yes, my lord, that's what the High Court also records.
Well, there's just one aspect which your lordship will keep in mind. A project of this type, which is done which is only of use in 8 months of the year. So the issue of decongestion and all also means that ultimately you will need.
The expert bodies have gone into it.
Passengers will
can't
still need,
stop monsoon,
I'm
man.
sorry,
It has to
the
be 8 months.
passengers will still need a jet for the rest of the 4 months. You will still have to build at the other place. It is something that you don't look at alternatives. You don't look at what's the least invasive thing. You don't look at the proportionality, because if you will still need the jetty.
Whether there were relevant reports which were considered by the High Court.
Yes, that the relevant report is not considered. The report says that you will need a jetty for 12 months of the year. The all-weather jetty is required for passengers. Now this will.
You have already passed an order, Mr.
Look, I'm just saying this is a matter which.
We don't permit post-order.
No, I'm saying, look, this is a matter which actually requires consideration. Only Your Lordship
That's
cannot
for us.
reconsider that.
That's for us to decide. Unfortunately.
Right, so obviously that is so. But please see, ultimately.
You also have to look. You can't only look at it from the angle of those who residing in the Taj Mahal hotel or the persons who are residing.
That no, it is.
That's what Mr.
Purabha,
That's what Mr. Hegde had argued. That this is a.
I'm following.
Mr. Hegde argued that this is the dispute between Amchi Mumbai and Tanchi Mumbai.
I don't know.
I told him that Amchi Mumbai doesn't reside near Gateway of India.
Your Lordship,
Amchi Mumbai resides in Girgaon or Goregaon or Dombivli and.
But Amchi Mumbai, they are the ones who everybody requires a 12-month jetty. Passenger jetty is required for the entire 12 months of the year.
You consider it.
And this huge
It's a matter within a policy domain.
But it won't serve the purpose.
Yes, thank you.
After all that, it's completely disproportionate, the invasion on the environment.
Thank you.
With pleasure. No, we're very grateful to your lordship for such a patient hearing.
Extremely patient.
Must
Pleasure hearing Mr. Rustamji after a long time.
and me.
So we are hearing you. You have to bear us. You have to bear us every day, and we have to bear you every day.
It's a pleasure.
But Mr. Rustamji's passion for environment, I have been seeing it from last at least 15 years.
I just wanted to say one thing. My lord has passed the order. The matter is over. The notion of Colaba as an elite area, my lord, that is something I take exception to. This is not.
I'm only talking about the buildings which are abutting that road. I'm not talking about the Colaba, which is that Colaba market.
Colaba is also Colaba market.
Colaba market. I used to walk down from Sarang to that market, so I know the plight of people residing there also.
Yes, and my lord, at the end of the day.
But you can't compare those buildings.
Yes, and that is also Colaba. And my lord, at the end of the day, the contention that this is NIMBYism or not in my backyard, I don't think that is fair. It is one thing to.
Everybody is entitled to fight for the protection.
My lord, at the end of the day, no illegality in my backyard is very different to saying it should not come here.
If there is an illegality, that has to be. I still recollect that Zoom matter which you had argued so passionately.
You're obliged.
Please, obliged, Your Lord.
Requesting for a password.
I'm here to oppose this petition.
Unless Mr. Parasat was here, only he'll be here, man.
Item 16, in the similar matters arising out of leave also granted, madam.
Do the same. How many years you have been inside?
I mean, 8 years, my lord.
7 years. Yeah, leave granted. Notice on suspension of interest and grant of bail.
Some delays there, my lord.
And don't.
Look, you can read. Not, your lordship has pronounced, but there is a slight difference. A candidate who is paying 12,000 rupees per annum is being treated as a non-local. Your lordship, kindly, this just has come to our notice. Say a candidate with identical background is being treated as local when he pays 12,000 rupees and the annual fee is 12 lakhs under the management quota, he is being treated as a non-local, my lord. This is the original application, my lord. Your lordship may kindly look at it. I don't want to. Kindly.
Go through the judgment, it is delivered by my
Your
learned.
lordship may kindly give me 1 week and raise this additional issue. Your lordship may kindly see what is happening there in Andhra. A purely temporary geo, unlike in Telangana where they had.
They already dismissed the similar matter.
Your lordship,
Thank you. They already dismissed the matter today morning. We know what is the judgment.
Same candidate.
We can't take a differing view in a day.
Right.
We will be accused of. At least we should abide by what we had decided in the morning.
Not good. Here something else has come to our notice, so I made an attempt, my lord, nothing more.
Thank you.
Madam Lords, 15th of July, the Lord passed an order and gave a direction to the High Court Lords to dispose of in 3 months. Lord. Thereafter, Lord, the matter has been listed about 7 or 8 times, Lord, still pending.
Rod. Instead of this court requesting the Madras High Court to decide the petition expeditiously and preferably within a period of 3 months. The white order dated 30th of April 2024. The matter has not yet been decided. Very good. We expect the High Court to give due deference to the request made by this court. We again reiterate the High Court. We again reiterate our request to the High Court to decide the petition expeditiously and preferably within a period of 3 months from today.
Grateful.
Please, my lords, in this case, my lords, a fraud has been played by the respondent on the honorable court, my lords.
You have already, madam, challenged it under section 34.
Yes, my lords,
So when you are challenging under section 34 is pending, how can we interfere?
during the pendency of that review petition, that arbitration proceedings had culminated into an award. And because it has been culminated into an award, my review petition was dismissed, my lord. My lords, there is a fraud played on the honorable court as well as on me as well. And fraud vitiates.
So if the fraud is played, that will be corrected in section 34 pleading.
My lords, then permit me to insert on.
Allowed to withdraw with liberty to prosecute. The proceeding filed by the present by the petitioner under section 34 of the Arbitration Act.
Please. No, this now, that similar issue your lordships have.
Keep it along with Dhiraj Murthy.
But the only thing is, my lord, in this case, 2 things have happened. The exam, my lords, is now 19th to 21st September. Of course, the last date to apply.
How can we do?
No, I'm only requesting one thing. I may be permitted to sit for the exam, whatever. Because no, otherwise I will lose my chance, my lords. Of course.
Lose this year if the constitution page decides, maybe you will be successful in the next year. The CB is yet to be even constituted.
No, I understand that, but I'm not claiming any right as such. I'm only requesting that I be permitted to apply and sit for the exam, my lord.
Open a Pandora's box, yes.
And Lordship will tag it with that, madam.
So, garage mortgage are tax करते हैं.
Great.
Lords, despite my objections, both in the reply to the 21 and my lords, my reply to section 11, my lords, the same nominee has been appointed. Lords, despite my objections, both in the reply to my 21 notice.
But then you had, on the earlier occasion, you had appeared and you had consented for an appointment of arbitrator.
My lords, there is no consent, my lords.
Yes, yes, you see the.
Not a consent as such, but you were present there. Not a consent has not been recorded, but.
My lords, will look at the reply to the 21 notice and also my reply to section 11. Not at both places I have objected.
Having heard the parties, it is appropriate to send the matter for arbitration, leaving all the conditions of the parties open. The parties agree that their results may not be recorded.
That is a.
My lords, what had transpired was, my lords, except for the name, my lords, the order was the same. My lords, the name was not given consent to by the.
You say that parties agree that reasons may not be recorded. That is a consent. And now a person has been appointed, you agree to it.
My lords, that's the same person they nominated in the 21 notice, my lord.
But then you should have objected that before the court.
My lords, my instructions are we've objected, my lords. When the order was passed in the Honorable High Court, my lords, except for the name, everything else was the same. My lords, the order came out much later. There was no consent given by us. My lords, there is no occasion for me to give consent anyway, my lords. I've objected twice. Lords, we'll just have reply to my 21 notice. So obliged.
Wait, please, my lords. My lords, order of this honorable court on 21st of April was for transparency that published the answer sheet. Just have a look at page 41, my lords. Order of 21st of April, my lords, first. And on the same day, 2 notifications were issued. Just have a look at page 41, my lords, first. My lords. Yes, page 41, my lords. An order was passed on 21st of April, man. This is regarding NEET, my lords, PG, my lords, exams. So, one of the direction was at page 41, published raw scores, answer keys, my lords, and normalization formula for transparency in multi-shift NEET PG exams. Now, my lords, in compliance of this order, 2 notifications issued on the same date. The first notification is at page 20. My lords would just have that. Serial number 5. My lords have it. It says, since the sequence of questions asked with a section of question paper of NEET PG is shuffled for different candidates and the order of 4 options for a question are also shuffled for different questions, correct answer key and response mark shall be displayed as the sequence in master setup. So this is all right. This is as per the question. Now, just a page prior to it. Now it's.
It will be appropriate that the matter is placed before.
I'm sorry, madam.
The bench decided by party wala.
Very
well. Since the present petition involves the interpretation of the order passed by this court.
Your Lordship.
Dated 29th of.
If I may humbly submit.
Yes, ma'am.
Yes. You find that it will be appropriate that the matter is placed before the bench decided by Honorable Justice.
Very well.
Your Lordship, if I may humbly submit, writ petition 456, Your Lordship, pertaining to the same matter, in that also we have the issue of transparency was let to be decided after the examination.
Well, since the counseling would be in this month and next.
Move the registrar.
Very well.
Page 134, exactly covered by my lord's order.